What should you know about a labor contract in Vietnam? Hello everyone, I'm Carlo Fabrizi, the Italian legal expert of Chinese and Vietnamese law. Today I'd like to provide key insights into the labor contract, a fundamental document that establishes the legal relationship between an employer and an employee. In Vietnam, there are two types of labor contracts, which are the open-ended contract and the fixed-term contract. An open-ended labor contract has no specific expiration date, meaning that the employment continues until either party lawfully terminates it. Instead, a fixed-term contract has a set duration but cannot exceed 36 months, and it may only be renewed once. If the employee continues working beyond the second fixed-term contract expiration, then the parties must sign an open-ended contract within 30 days from the expiration date. So, regarding the content of a labor contract, to be legally valid, it must include mandatory terms to ensure clarity and compliance with the labor regulations. The first one is the basic information about both the employer and the employee, such as their full name and address. Also state other details, such as the tax code of the employer and the ID number of the employee, as well as a phone or email contact to avoid misunderstandings. The second one is the contract duration, which cannot exceed 36 months for a fixed-term contract, as we said. Then there are job description and workplace to ensure a mutual understanding of the job expectations and responsibilities. The fourth is salary terms, which must comply with the Vietnam's minimum wage requirements, and also the payment method, which can be in cash or by bank transfer, or paid monthly or by bi-weekly basis, to avoid potential disputes. Then the fifth is the working hours, break periods, and leave entitlements, aligned with both labor law and internal company policies. As last, the sixth one is social, health, and unemployment insurances provisions, defining the type and extent of the coverage. Most terms in a labor contract can be modified or supplemented through an appendix, except for the contract duration, for which the parties must sign a new contract instead of using an appendix. As next, we will talk about how to unilaterally terminate the labor contract. Actually, for employees to terminate the labor contract before its expiration, it's necessary to provide at least 30 days notice before resigning, unless they fall under exceptions listed in the clause 2 of Article 35 of the Labor Code, which are non-payment of wages by the employer or the failure to assign agreed upon work by the employer. However, for the employers, it's quite hard to terminate the contract. They can only terminate an employee under specific conditions outlined in Article 36 of the Labor Code, such as if the employee, for example, is absent for 5 consecutive days without a reason. However, we may talk about unilateral termination in details into another video, as it's quite complicated subject. As next, in certain cases, a labor contract may be declared invalid by the court if it contains illegal provisions or it's signed by an unauthorized representative or involves work prohibited by the Vietnamese law. If this happens, rights and obligations of both parties will be handled according to the collective labor agreements or legal provisions. That concludes our first overview of labor contracts in Vietnam, and I hope you found this information helpful and that it may support your operations in Vietnam or your employment in here. Then please stay tuned for more in-depth discussions on the Vietnamese labor law, doing business in Vietnam, and other matter relating to this fantastic country in my upcoming videos. Please remember to subscribe and like. Thank you for watching. See you next time.